The following lecture covers voir dire, or as we say it in Texas, voir dire. It's divided into two parts. The first part discusses the fundamentals of jury selection, and the second part is a mock jury selection that I conducted at the University of Texas School of Law. I especially want to thank the extraordinary director of UT's trial ad program for all that she did for me and all the help she gave me, Professor Tracy McCormick. Now let me talk to you about the goals of jury selection. There are many goals, but to me there are three that are the most important. The first goal is to create successful challenges for cause. Now I know you've studied that, but let's review the bidding for a moment. When do you get a challenge for cause granted? It's when the judge is persuaded that a panelist has exhibited what's generally called a fixed state of mind, has some bias or prejudice about a significant part of your case. It could be the law, a panelist who simply can't follow the law on punitive damages, a panelist who just doesn't like your client, thinks anybody from the corporation you represent has got to be a crook because of Enron. Whatever the reason, the judge is required to disqualify that juror, that panelist from the jury. Now, and to understand why that's so valuable, you have to understand the relationship between challenges for cause, where the judge strikes the panelist, and peremptory strikes. Peremptory strikes are the strikes you're given, usually no more than 3 or 4 or 5, in a complex case, maybe 6. These are strikes you, the lawyer, are given and can use on any panelist for any reason except for race or gender. You don't like the way the panelist in the first row answered you, seemed a little hostile. You don't like the earrings the panelist number 2 is wearing. Strike her. Strike him. But remember, you have so few of these strikes. You've got to husband them. You make one mistake. There's so little margin for error. Make one mistake. Let one bully boy juror on that jury, and it can be lethal to your case. Now, what happens when a judge disqualifies a panelist for cause is that it creates a 2-strike swing in your favor. You don't have to use your strike. The judge does it for you on this panelist you don't want, and instead you come over here and use that same strike on another panelist you don't want. And trust me, there's never going to be a panel when there aren't panelists you don't want on your jury. So you have this very valuable relationship that I hope illustrates how important it is for you to create successful challenges for cause. And on this mock jury selection, you're going to see that demonstrated, how you go about doing it. Second goal, you want to exercise intelligent, informed peremptory strikes. Now what I mean by that is that when you use those strikes for whatever reason, you want to know as much as you can about the panelists. To do that, you have to elicit answers that really tell you something about the panelist. Even answers that some lawyers would consider poisoning the well, making the other panelists against your case. It doesn't work that way. If someone doesn't like you, doesn't like the kind of case you've got, can't give punitives, you need to elicit that information, and I'm going to demonstrate that too. Now, what have we been talking about so far? We've been talking about ways to get rid of panelists we don't want, either through challenges for cause or through the proper and intelligent use of peremptory strikes, those few strikes that you get to use for whatever reason you want. What comes next? Well, this may, as young lawyers, surprise you somewhat. The next goal is to commit those remaining panelists, the ones you don't want to get rid of, to your client and your client's cause. Now, how do you do that? This may sound a bit esoteric, so stick with me. You do it by learning how to elicit answers. Panelist number 1 over here. Elicit answers from this man's life. Get him to talk about his own experiences that mirror and reflect almost exactly the experience that brought your client to court to begin with. I'm going to give you an example in a minute. But what I want you to learn to do is to allow the panelist experience to become a metaphor for your own client's experience. Why your client's in the courtroom? Why? You'll see. You'll be able to argue your case without mentioning the facts of your case. Here's what I want you to be able to do. I want you to be able to create an experience that so closely mirrors your client's that when your client finally gets on the stand, the panelist says to himself, aha, now I see why the lawyer was asking me that. That's exactly what happened to me. And other members of the jury are going to say during jury selection, that's exactly what that panelist was talking about. Now I understand. Let me give you a concrete example. I call this concept linkage. And I discovered it during a murder trial that I tried back in 1979. The facts were horrific, so let me tell you a little bit about it. A woman was accused of shooting and killing her husband and then dismembering him with a chainsaw. Not only did she do that, but the chainsaw broke and she went out to get another band. She then took the body to California and buried it on her father's ranch. So during jury selection, I was trying to educate the jury, this is back in '79, I was trying to educate the jury on the right of a wife in that circumstance to defend herself with lethal force if she felt her life was in danger. And let me tell you something, in Texas in '79, that right was not a given. It simply was not. Well, I was doing what we used to do back then. I was selling my case, I'm sure, trying to make my argument during the jury selection period when I heard the sound in the back of the room. It was very loud, and a woman was sobbing. She was number 79. I remember it as if it happened yesterday. We were never going to reach her. The prosecutor couldn't get her on the panel, nor could I. And I don't know what it was, maybe a combination of instinct, good manners, good luck. I took a glass of water and I went to the back of the courtroom and I said, "Are you all right?" And she said in a voice that everyone heard, I don't think she did it intentionally, she stood up and she pointed to my client, who was a diminutive woman, and she said, "Mr. Berg, if my daughter had done what your client did, she'd be alive today." Well, I'm not a psychologist, and I can't tell you the levels on which that affected the panel. But here you have a mother who becomes the surrogate mother to my client and telling the panel what she did, although it was heinous. I, a mother who lost a daughter, understand. And the jury acquitted in 45 minutes. There was that moment, I'm sure, when they began to hear the facts of the case, that the jurors said to themselves, "That's what that lady on the first row told me, on the back row told us." That's what she felt, and I feel it too. That's what I'm talking about when I say I want you to create a metaphor from the experience of the panelists that mirrors that of your client. Let me tell you something. It's not just criminal cases. It works in the most complex patent litigation you'll ever be in. And I'm going to demonstrate that when you see the videotape later of the mock jury selection. So that's the goals. That's the things that I want you to try to create, try to achieve during jury selection. How do you get there? Well, I want you to imagine yourself in a courtroom, which shouldn't be too hard because you are in a courtroom. What's the first thing that happens? Say you've got a very simple case, straightforward case, no press, no reason to bring in a lot of jurors. 24 individuals come padding down that aisle silently. The first time you do this, it's like a mass blind date. They don't want to be there. You're nervous. Here is your opportunity, though. Remember, this is your opportunity to create a rapport with these folks about the issues that are going to decide the case. I always think, when I think about jury selection, about Hamlet, when he marvels, remember the play within the play, and he says, who is he, the actor, to Hecuba, the role he's playing? And who is Hecuba to him? He's saying, how on earth does the actor get inside that role, get inside the fictional character's head and become that character? Well, that's what we have to do with the panelists. But we don't get a dress rehearsal. Here in your trial ad program, this is as close as it's going to get. Getting some experience in other cases, that's as close as it'll get. But this is your one chance with this panel that comes in. So what do? I'm going to give you some very practical suggestions. You will find right by you a jury chart that I drafted and had distributed before we start. And this is the first thing I want you to do. The viewers are seeing this on the screen. The viewers are seeing a jury chart. It's blank. First thing you want to do is you want to make sure the jury chart is accurate. You write down the numbers of each seat. You see here we've got 3 rows of 8 apiece. You write down the numbers, and then you fill in the name of each of the panelists. Now, because you know what you're doing, you've had a questionnaire that you've sent out. Virtually no judge in this country refuses the use of questionnaires anymore. And you've gotten a little bit of information about these folks before the case even started. If not, at least you've got one of these skimpy jury information sheets that gives you the bare bones about them. So, you fill in the name of the first panelist, and that would be Bob Smith. Now, what you learn from the information you've got is Bob Smith is a union worker, and his wife is a nurse. So you say to yourself right off the bat, here in seat number 1 is a juror who has probably got a pretty compassionate family, probably liberal. On the other hand, I represent a corporation, so there may be some antagonism there. Now I'm just doing this is superficial, but I'm giving you the kind of thinking that you have to engage in. So you say to yourself, but wait a minute, I'm representing a corporation as plaintiff. I'm the David in this case, and I'm suing a huge corporation. You know what? On a scale of 1 to 4, 5 being the best possible juror, I'm going to give this guy a 4, but I'm going to ask him more questions. Then you look at panelist number 2, Jill Salazar. It's not the same story. She wrote down, when it said, what do you do for a living, or what is your occupation, she wrote financial. That didn't tell you enough, but it's enough to make the hair on the back of your neck stand up as the plaintiff's lawyer. You say to yourself, look, I've got kind of a weak damage model here. I don't want a bean counter on my jury, I don't think. That's not what I want. And she works for a large communication company. I've got a small corporation. You know what? On a scale of 1 to 5, I'm going to give her a 1 to 2. I'm going to put a question mark or 2 down by her name, and I'm going to question her some more. And why am I going to question her more? Now, here's something I don't want you guys to forget. Anyone who selects a jury, this jury chart that you have in your hands is a report card on each of those panelists. So in order to do what? To use intelligent, informed strikes or to create challenges for cause, you've got to know as much as you can about each and every one of them. We're going to talk about how to do that in a minute. Now let me give you one of the few inviolate rules, hard and fast rules of my book. When you are talking to the panel, never take notes yourself. You can turn around and make a very quick note as long as you're not distracted from them and don't turn around too long. But if you stand there and you're trying to gain the confidence of the panelist and you're writing her answer down at the same time, and I used to do this, trust me I did as a young lawyer, and you're looking over here for body language and back there for someone who's scowling, and you can't do it. I don't care if it's your mother and dad or your cousins. If you've got someone sophisticated you know, someone intelligent who will take copious notes about every reaction, who will tell you what someone said and how they said it, get them in the courtroom and let them be your extra eyes and ears. That way, you will continually refine each and every panelist's information. And these rankings that you have from 1 to 5 are going to make a lot more sense. And when it comes time to strike the jury, you're going to strike a far better jury. The next step is yours, literally. You have to walk up in front of that panel. If you're plaintiff, you go first, defense second. And when you do, I talked about this a little bit earlier, you have to take command of the courtroom. You're not going to do it, as I've seen so many times, you fumble around with papers. First, can you imagine how you'd feel about somebody watching them fumble around and figure out what they're going to say or reading it off of a notepad? Doesn't sound very sincere and it doesn't make you look good. You want to take real command of the courtroom. You want those panelists, you want them to know, I know what I'm doing, I know what I want from you. You do it without arrogance. But as I've seen so many times, it's not going to happen to you, I promise, because you now know what the goals are and what you're doing. But so many times, I have seen lawyers ask a few good questions and then all the wind is gone from their sails. And you know how they finish their jury selection? They'll say, now, I take it from your silence that each of you will follow the law of fraud as His Honor instructs you. Well, no. It's not, their silence isn't telling them they'll do anything of the sort. Their silence is telling them what? Telling the lawyer what? That they're bored to death and he's not getting any information that matters. I don't want that happen to you. Next step. You have to put the panelists at ease. You've got to do that. That's part of your function. They're doing something that they've never done before. They're going to be talking about things they've probably not even talked about with their families. So you've got to put them at ease. And how do you do that? You do it by, in my view, you can make a couple of confessional statements to them. You can tell them, look, these are my clients. This is John and Fiona, they're business partners. They're married also, John Alexander, Fiona Water Street. These are my clients and I want to do a good job for them, so you'll understand. I feel a little nervous today. And that makes you more approachable. That makes you not just a suit up here talking, but a human being that they can talk to. And they really need to let down the barriers and tell you things that really come from their heart. First thing you do, Not only do you put them at ease by telling them you're a little nervous, you've done what? You've humanized your client. You've done what? You've humanized your client. How have you done it? By putting your arms around your client, by standing closely by them. If I say, those are my clients over there, what does that physical distance tell you about your relationship to your client? And as I am fond of saying, your rapport with the client rubs off on the jury. And I'm also equally fond of saying, and probably say throughout this DVD, and I know in my book, bad blood follows you into the courtroom. That jury will get it. Trust me. So you want to show some warmth. Let me tell you another very important confessional statement that you're going to have to make. You have to make it noble for these panelists to be disqualified from the panel. And it is, in my view. So you tell them, you know, I've lived all my life in the law, but if I had to sit on, say, a child molesting case, I'd have to raise my hand and say, Your Honor, I just can't sit on this case. I can't be fair. So you make it okay for them to say to the judge, I can't be fair. You're starting to open them up. You don't say to them, as I've heard so many times, I want to find out your biases and prejudices. You might as well ask for a showing of hands of all the bigots on row 4. You're just not going to get any information. You want to ask them in a particular way. I'll give you that way in a minute. I call it the keys to the kingdom. You're going to find out how to ask questions that will elicit the answers you need. But you, from the very first moment you start talking to these folks, you've got to let them feel comfortable with you. I'm going to give you one last hint. And remember, there's far more detail in my book. You tell the panelists here on row 1, so all the panelists here, if there are matters that are private, as you've indicated already, Ms. McCormick, we'll take that up with the judge. We always do. Now, what have you told Ms. McCormick? Ms. McCormick, should she have a private issue, can take it up as we always do. Isn't that comfortable? That's the rule here. You're not doing anything wrong. Let's go up and talk to the judge out of the earshot of these other people assembled, these folks you don't even know. So put these folks at ease. And in my book, I make other suggestions, but you will have your own way, ways you deal with people in your own family of putting them at ease, and you'll find that's what you're dealing with in the courtroom. It's all about relationships. You can do that very well. So you've taken command of the courtroom. You've put the panelists at ease. You've humanized your clients. What comes next? These are the keys to the kingdom. This is the gift of modern trial science. I want you always, and for most of the time you stand on your feet, to ask open-ended questions. Now, what do I mean? Let me illustrate by telling you what I used to do and what we all used to do back in the 70s and even the 80s. We would try, as I said before, you heard me mention selling your case. I would say to a panelist, now, sir, if I can prove that the defendant over there caused the accident that resulted in my client's injuries, would you be willing to return an award of money damages not only for out-of-pocket expenses but for pain and suffering? Well, what's this poor panelist going to do? He's intimidated into answering what? Well, sure, I'd do that. But that is not an answer that comes from his heart or his mind. That's an answer that I forced him to give. Instead, think of it this way. Think of the result you'd get if you really are looking for information. If you went to the panelist and you said, sir, you know, there's been a lot of controversy about soft damages, as they're called, pain and suffering. How do you feel about that? Have you discussed that with your family or friends? How do you feel about that? Get them talking about their opinions, their beliefs, things they feel, and you're going to get a world of information. So now you know to ask open-ended questions. What then should you ask about? You ask questions about any significant aspect of your case. In that murder case I told you about, it was the law of self-defense itself that triggered an emotional response. In most cases, it's going to be the most powerful themes that you've developed during focus groups or just thinking about your case. If you can't afford a focus group, and talking to your friends about the case. Don't tell them which side you're on, but run the facts by them. Run it by them in a way that accentuates the other side and not your own, and feast on that feedback. Get the information you need that you can test with the panelists. I'm going to do that in just a few minutes on this videotape that you're going to see of the mock jury selection. I'm going to show you how to use a powerful theme in your case to tell the client's story before the case even begins. Now, when you finish this questioning, and by the way, this kind of questioning may get you all the way to the end of the time you've been allotted. You may get such valuable discussion going. You may say, do a round robin. Now, Ms. Jones, you heard what Mr. Smith said about punitive damages. What do you think about what he said? I haven't asked a single thing that's going to cause her to answer my way, but I've asked a question that'll get me some information about what she really thinks. And by the way, there are lawyers who do not like this method. They're fearful, and they're probably right, that there's going to be an answer that's going to make you look bad. Miss Jones here tells me she doesn't like plaintiffs' lawyers. They're all greedy. Mr. Smith says he thinks punitive damages should be outlawed. Well, don't you want to know that information? How can you make a strike unless you know this negative information, the feelings these people really have deep inside their souls about you and your case and your client? Next step. There's going to be a few people on that panel that you haven't gotten to talk at all. And these silent panelists can kill you if they get on the jury and you don't know anything about them. So you ask the panelists something, individual questions now, and they don't necessarily have to be open-ended, but you ask them questions that'll get them talking about anything. Ask them about their kids. Everybody loves to talk about their kids. And then you ask them another question. You say, do you believe in corporal punishment? Did you spank your own children? Now that may sound totally off the wall, but in every case you're in, civil or criminal, punishment is an issue. You try to get punitive damages from people who don't like to punish. You need to know that, don't you? Now, the next step sequentially is that you take the panelists up to the bench whose answers have caused you concern that they can't follow the law, they don't like your client, something about them, you want to get rid of them, and you want the judge to disqualify them. You know you want to get rid of them, but you don't want to use your own strike, so you try to disqualify them for cause. Now, in the mock jury selection, which you're going to see in a bit, there is I attempt to demonstrate that with a Mr. Matson on that panel, who expressed some reservations about his ability to return a verdict including punitive damages. And there's a 6-step process that I talk about. These are steps that I learned from a great master, the lawyer Racehorse Haynes, the great Texas criminal lawyer, that I think will not only help you learn how to disqualify panelists you don't want, get the judge to disqualify them, it'll also teach you how to get them off and keep them off the panel. So that's all I'll say right now, but you'll see a demonstration in a few minutes. The final step, of course, is striking the jury. Now, I also demonstrated that and talked about 10 rules, 5 of the 10 rules that I have for striking a great jury. But let me tell you one now, and that is at every step, no matter which of those rules you're following, your instinct trumps those rules. Listen, men in this audience, you don't know as well as the women do. Listen to your instinct. They will trump the rules every time. You don't want somebody, strike them. Now, let me give you the setup about what you're about to see. A couple years ago, my son Gabriel and I were asked to try a case in New York City. On the one side, you had a sports agency owned by our client, a man named Eric Fleischer. And the defendant in the case was his former president, the man he had brought along since he was 22 years old, who by age 28 became the president of Eric's agency, and who bailed out with some of his best superstars, including Kevin Garnett of the Minnesota Timberwolves. So Eric sued, and his agency sued the defendant for breach of fiduciary duty. But breach of fiduciary duty is an abstract concept to a jury. And when we focus grouped this case 3 days before we started, we got into it very late, we learned what I suspected. The jury was most compelled and most moved by the theme of betrayal. They said that that young man stabbed Eric Fleischer in the back. Now, what you're about to see